Guys, it's me Vipina. Thanks for joining me today. If you are new to this channel, please consider subscribing in this channel. Today we are going to discuss on different forms of business organizations. So the first one, it is sole proprietorship, a business which is owned, managed and controlled by a single individual who is recipient of all profits and bearer of all risk is known as sole proprietorship. Let's move on to the features of sole proprietorship. First one, individual ownership. That is, there is single person ownership in sole proprietorship. Second one man control. That is, the proprietor alone takes all the business decisions. Then unlimited liability. That is, the proprietor is personally liable for all the debts of the business. The next feature, no separate legal entity. That is, the law makes no distinction between the proprietor and its business. So there is no existence for business apart from its owners. Then fifth one, no profit sharing. That is, the sole proprietor alone is entitled to all the profits and losses of the business. Then small scale. Always a small scale business will be opened up by sole proprietors. Since a sole proprietor can arrange limited funds and managerial ability, this business is always small scale in nature. Then last one, no legal formalities. That is, no legal formalities are required to start, manage and dissolve sole proprietorship concerns. Simply a license can be required in some kinds of business. Next one, partnership. First of all, let me tell you that all partnership firms in India are governed by the Indian Partnership Act 1932. So here a definition given by section 4 of Indian Partnership Act 1932 is, partnership is the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. Then next, let me discuss what is partnership deed. That is already in definition we have explained now. That is, partnership is based on agreements. So those agreements which are written in nature is called partnership deed. Simply a document in writing containing different terms and conditions of partnership as agreed to by the partners in regard to operators of business and its affairs is called partnership deed. Next, features of partnership. First one, number of members. As per Partnership Act 1932, minimum 2 or more persons are required to form a partnership firm, and maximum of 10 in case of banking business and 20 in other types of business. And you should note this one, that is LLP, Limited Liability Partnership. It's a new concept, that is restricting the liability of partners to limited in this kind of partnership companies, and this is regulated by the Companies Act. And as per this Company Rules 2014, the maximum number of members can be admitted in LLP is 50. That is also a probable question for NET or any type of competitive exam. So the maximum number of members can be admitted in an LLP company is dash. The answer will be total 50. Okay. The next feature, agreement. That is, always a partnership firm is based on agreement, and that agreement can be either oral or written agreement, and written agreement is called partnership deed. Next, it is lawful business. Lawful business. That is, a partnership can only be formed for a business which is legal in nature. The next feature, non-transferability of shares. That means no partner can transfer the share in partnership without the consent of other partners. Then next it is unlimited liability. That is, each partner is liable to an unlimited extent for the firm's obligations towards outsiders. Then no separate legal entity. That is, a firm has no separate legal existence independent of their partners. Next it is registration. That is, a registration of firm is optional in nature. So these are the features of partnership. Now we can discuss the types of partnership. Mainly, we can broadly classify the partnership into two categories, that is on the basis of duration and on the basis of liability. So on the basis of duration, partnership can be partnership at will, particular partnership, and last one, joint venture. And on the basis of liability, we can classify into two, general partnership and limited partnership. So what is partnership at will? Partnership at will is a partnership formed for an indefinite period. That is, a partnership firm which is constituted for an indefinite period is called a partnership at will. Here, the time period or the purpose of the firm is not mentioned at the time of its formation. That is what the speciality of partnership at will. Next, it is particular partnership. These are those partnerships formed for a specific time period or to achieve a specified objective is called a particular partnership. And it is automatically dissolved on the expiry of specified time or completion of certain purpose. The next it is joint venture. Joint venture is organized for completing a specific project during a certain period. That is what called joint venture partnership. And all members of joint ventures are personally liable for its debts and obligations. Then next it is on the basis of liability, we can classify the partnership as general partnership. So general partnership is those form of partnership where the liability of partners is unlimited and the joint registration of firm is optional in nature. And this kind of partnership is affected by the death, lunacy, insolvency or retirement of partner. The next it is limited partnership. In this form, liability of at least one partner is unlimited, whereas the rest may have limited liability. In case of limited partnership, at least one member is having unlimited liability and the remaining members can have limited liability. Then next, types of partners. First one, active partners. So active partners are those partners who contribute capital, also take part in management, and also they have unlimited liability and share profits and losses of the firm. So they are active throughout. Then next it is sleeping or dormant partners. These are those partners who is otherwise called inactive partner. Inactive in the sense they does not participate in management. Except this feature, he contributes capital, also shares the profits and losses of the business. Next it is nominal partner. Nominal partner. These are those partners, one who allows the use of his name by a firm. That is, he does not contribute capital and does not participate in management and also does not share profits and losses. He simply contribute his name to use of his name by a firm. Then next it is secret partners. Secret partners are those one whose association is not known to the general public. That is, other than this distinctive feature, he is like rest of the partners in all respects. Except this, that is, these partners' name is unknown to the general public. Except this feature, the secret partners are like other partners. The next it is partners by estoppel. Partners by estoppel means in case a person represents himself or herself by words or action or has allowed himself to be represented as a partner of the firm, even though he is not a partner, he is called partner by estoppel. That means a person is pretending through his words or action that he is a partner of a certain partnership firm. In such Next, it is partner by holding out. This is the case when a person is declared as a partner and he does not deny this even after becoming aware of it, and he becomes liable to the third party who lends money or credit to the firm on the basis of such a declaration. That is, partner by holding out means a person aware of the fact that he is not a partner of a particular partnership firm, but somebody is declaring that he is a partner of the firm, and if he does not deny the fact, and some outsiders is giving amount to partnership firm, and if the firm is not able to meet up that debt, in such case that partner whose name is declared as a partner can be called partner by holding out, and he becomes liable to pay off the debts. Now let's discuss minor as a partner. Can a minor be a partner of a partnership firm? This is a question towards you. So never ever a minor is competent to enter into a valid contract with others. So he cannot become a partner in any firm. This is a fact. That is, minor is incompetent to enter into a valid contract with others, and he cannot become a partner in any firm. So a minor, but the thing to be noted is that a minor can be admitted to the benefits of partnership firm with the mutual consent of all other partners. That in such case, his liability will be limited to the extent of the capital contributed by him in the firm, and a minor can share only the profits and cannot be asked to bear the losses. That is, simply a minor cannot be a partner, but with the consent of all other partners, a minor can be admitted to the benefits of a partnership firm, and in such case we cannot ask to bear the losses by a minor. Only he can accept the benefits offered by the partnership firm. Also, his liability to be determined based on the capital contributed by him. So this is the case of minor in case of partnership. Next, we can discuss about Hindu undivided family or joint Hindu family business. This is a old form of business which is found only in India, and this is what the form of business organization which is owned and carried on by the member of HUF, member of Hindu undivided family. Then this type of business is always governed by the Hindu law. And next it is features of HUF. Features of HUF. So first one, it is membership by birth. That is, a person automatically becomes the member of HUF business by taking birth in that family. That is, by virtue of their birth, they are getting membership in the HUF business. Next, it is minor members. Even minor members can become full-fledged member of the Hindu undivided family. The next, it is only males as members. There is a restriction of membership of females. That is another feature. The next, it is no limit on number of members. In case of HUF, there is no limit for number of members to be admitted. That is, the other members of the HUF family, HUF business is called co-partners, and the eldest member of the HUF business is called Karta. So there is no restriction on the number of co-partners in HUF business. The next it is management by Karta. Karta, I already explained. Karta is the eldest member of the HUF family. That is, senior-most member of the family is called Karta, and the management is always done by the senior-most member of the family, that is Karta, and other members here called co-partners. Next, it is liability. Liability of Karta is always unlimited, whereas liability of other members is limited to the amount of their share in the property. This is the difference between Karta and co-partners. That is, the liability of Karta is always unlimited and the co-partners liability is always limited to the extent of their share. The next it is right to accounts. All members can inspect the accounts of the business. That is another feature. Then next feature is that governed by Hindu law. That is Hindu Succession Act 1956 governs the rights, duties and liabilities of the members of HUF business. The next it is perpetuality. Its continuity is not affected by the death of family members. After the first generation, next generation controls the business and the business goes forever. There is no end to HUF business. Its existence is continuous in nature. That is what called the feature of perpetuality. Then next we can move on to cooperative societies. Cooperative societies are governed by the Cooperative Societies Act 1912. So what is a cooperative society? It is a voluntary association of persons who have joined together for the economic interest of its members. So this is what the definition given for cooperative societies, and every cooperative society is to be compulsorily registered under Cooperative Societies Act 1912. In order to form a cooperative society, there requires consent of 10 adult persons. Then the capital of a cooperative society is raised from its members through issue of shares. Then next it is features of cooperative society. First one, registration. That is, a society must be registered under Cooperative Societies Act 1912. And on registration, society becomes a body corporate having a separate legal entity with perpetual succession and limited liability of members. The next it is voluntary association. Here membership is open to all irrespective of their religion, caste and gender. That is, any person having a common interest may join and leave by giving a prior notice to cooperative society. The next it is minimum persons. A minimum of 10 adult persons are needed to form a cooperative organization. Then next, service motive. The primary aim of every cooperative society is to provide some service or benefit to its members. Next it is democratic management. That is, business of cooperative society is managed by a managing committee which is elected by the members. That is, democratic management policy is followed in cooperative societies. The next it is one man, one vote. That is, every member of the society has one vote irrespective of the number of shares held by them. Next it is finance. The capital of cooperative society is raised through issue of shares to its members, and it can also raise loans from banks. Next it is state control. That is, government exercise control over cooperatives to protect the interest of members of cooperative societies. Then next we can move. Next it is joint stock company. Joint stock company is a voluntary association of persons having separate and distinct legal entity, perpetual succession, common seal and registered under Companies Act 2013. Here the shareholders are the owners of the company and the board of directors is the chief managing body elected by shareholders. Then an indirect control is exercised by owners over the business through this board of directors. Then its capital is divided into smaller parts called shares, which can be freely transferable from one shareholder to another. The next it is features of joint stock company. First one, it is an artificial person. That is, a joint stock company is a creation of law. Hence, it is an artificial legal person who has no body or soul. Therefore, for its own business purpose, it can hold property in its own name, can enter into contracts and can sue and be sued by others. Next, it is distinct legal entity. That is, the company has an entity or a personality which is absolutely independent and separate from the entity of its members. The next, it is number of members. Minimum 2 people and maximum 200 number of members is required in private company. And also you should note this, minimum 2 directors are required in case of private companies. Then in case of public company, minimum 7 members are required to form a public joint stock company, and there is no limit for maximum members who can be admitted in public joint stock companies. And the number of directors required in case of public company is minimum 3, and in case of private company it is minimum 2. These are the probable areas where objective type question can be asked on the number of members. Then next it is perpetual succession. That is, members may come and go, but the company remains active. The existence of company is continuous in nature. The next it is limited liability. The maximum liability of a member is limited to the unpaid value of shares. That is, the shareholders' liability is always limited to the extent of the share value held by them. Then next it is transferability of shares. The shares of a company are transferable except in case of private company. Next it is common seal. As an artificial person, a company cannot act and sign itself because the only individuals can sign. So it acts through human beings known as directors. So all the acts of the company done through the directors are authenticated by a common seal of a company. That is what called the official signature of the company. The next it is management by board of directors. Directors are elected representatives of the members of the company. So through the board of directors, a company is managed in a democratic manner. Next, types of companies. We can classify the companies into statutory company, foreign company, holding company, subsidiary company and government company. Along with that, we can classify into public company and private company also. So first one, statutory company. Statutory companies are created by a special act of central or state legislature. For example, we can say State Bank of India, Unit Trust of India, LIC, etc. The next it is foreign company. A foreign company means incorporated outside India but having a place of business in India is called foreign company. Next it is government company. Government company is a company in which not less than 51% of paid up share capital held by central or state government or jointly by them is called a government company. Then along with that, we can discuss the public company and private company also. A public company is those company which is not a private company and it has minimum paid up capital of rupees 5 lakh and it has minimum 7 members and no limitation for maximum members, and it has minimum 3 directors. Whereas a private company is one which prohibits any invitation to it prohibits any invitation to public to subscribe to its shares or debentures, and it has minimum 2 members and maximum of 200 members, and it has a restriction on transfer of shares, and it has a minimum paid up value of rupees 1 lakh, and it has minimum 2 directors, number of directors minimum 2. This is the private company. The next we can discuss the stages of formation of a company. What is formation of a company? We can say it's a complex process involving several legal formalities and procedural decisions. So the formation of a company involves four different stages. First one, it is promotion, then the stage of incorporation, and the third stage capital subscription, and the final stage commencement of business. So what is the promotion stage? It refers to some total of activities by which a business enterprise is brought into existence. It involves discovery of business idea, investigation and assembling necessary resources to set up a profitable concerns. And the persons or group of persons who performs the work for promotion and forms of a company is known as promoter. That is, those who engage in the stage of promotion of a company is called promoters. So it can be the sum total activities by which a business enterprise is coming into existence. Then the second stage of formation of company is incorporation. That means the registration of a company as a body corporate under the Companies Act 1956 is called the stage of incorporation. It involves the approval of name, filing of necessary documents, payments of fee, registration and obtaining certificate of incorporation. And when a certificate of incorporation is issued, the registrar of companies allot a CIN, that is corporate identity number, to the company. It is like a birth certificate of the company. Birth certificate of the company is CIN, that is corporate identity number. Then next it is stage 3, capital subscription. A private company can commence business immediately after obtaining incorporation. But in case of public company, it must raise necessary capital to obtain commencement of business certificate. So the capital here, a private company can commence business immediately after obtaining incorporation. But a public company must raise necessary capital to obtain commencement of business certificate. For obtaining capital subscription, there are several steps involved. First one, SEBI's approval is required, then filing of prospectus, then appointment of brokers, then underwriting, issue of prospectus, then listing procedures, then subscription, allotment, refund, and finally the issue of share certificates. Okay, these are all the things involved in capital subscription phase. And the final stage of formation of company is commencement of business. In order to commence business, a public company has to obtain certificate of commencement of business. For this, certain documents to be filed with the registrar of companies. Main important documents to be filed are: first one, a declaration that 90% of the issued amount of capital has been subscribed. So there can be a probable question, that is the minimum percentage of capital to be subscribed is 90%. The next, it is a declaration that all directors have paid in cash in respect of allotment of shares made to them. And the third document required is a statutory declaration that the above requirements have been completed and must be signed by the director or secretary of the company. These are all about the phases of the formation of company. Then next we can move on to the topic, that is choice of form of business. That is, different factors are there in order to choose the form of business that is suitable to form an organization. So what all are the different factors to be considered while forming a business organization? That are: first one, cost and ease in setting up the organization. That is, while setting up a business, setting up costs are low and the legal requirements are minimal in case of sole proprietorship and partnership form of business. In case of cooperative societies and companies, it have to be compulsorily registered and the formation is quite lengthy and expensive process. Then next it is liability. Liability also a factor while choosing the form of business. We know sole proprietorship and partnership firms where the liability of the owners are unlimited, But in case of cooperative societies and companies, the liability of the members is limited. So from the point of view of liability, the company form of organization is more suitable. And regarding next, it is continuity. The continuity of sole proprietorship and partnership firm is affected by events such as death, insolvency, insanity of the owners, whereas the continuity of business in case of joint Hindu family business, cooperative societies and companies are not affected by the death or what called insanity of the members. So continuity also a factor. Then management ability. A sole proprietor may find it difficult to have expertise in all functional areas of management, but in other forms of organization like partnership and company, no such problems exist. The next it is capital consideration. That is also a factor that determine the choice of form of business. And next, degree of control. The degree of control that can be exercised by the owner also varies from one business to another type. The next is nature of the business. That is direct personal contact, whether needed or not needed. That also determines the choice of form of business. So these are the things to be noted regarding the forms of business organization. We had a quick idea of what all are the different forms of business organizations and its features and the different things that are essential to understand about the form of business. So thanks for watching, and if you are new to this channel, please consider subscribing in this channel. Once again, thank you.